Chris, this is Warren Hicks. Is Mr. Layfield with you? You're on mute.
Mr. Layfield is not with us. He is not physically here with us.
Oh, okay, I see him on there now. Thank you.
Thank you.
All right, let me ask, does anyone know, from looking at the list, is there anyone missing? I think I see everyone who was on my list. Does anyone know if anyone's missing? I see everyone that I have on my list.
I believe everyone is here from Axion.
Great, thanks.
Everyone is here from Orion.
Great.
And same as
from the public staff.
as well.
All right. Sounds good. All right, Kim Mitchell, whenever you are ready, you give me the sign. All right. All right, good afternoon, everyone. We'll be in order at this point, and we'll open the record in this matter. I am Commissioner Dan Clodfelder, and I have been assigned by Chair Charlotte Mitchell to preside over this panel hearing. Joining me this afternoon are the other panelists. Joining by remote connection are Commissioners Lyons Gray and Kim Duffley. As is required by the State Government Ethics Act, I remind the members of the panel of our duty to avoid conflicts of interest and inquire at this time from Commissioners Gray and Duffley whether they have identified any conflicts of interest. Okay, Madam Court Reporter, let the record reflect that no conflicts have been identified, and we will proceed now to call for hearing docket number SP-13695 sub 1, which is the verified petition for relief filed by Orion Renewable Resources LLC, which I will refer to as Orion. On March 9 of this year, Orion filed a verified petition for relief, including attachments designated attachments A through E. In the petition, Orion complained that its proposal for a contract in tranche 1 of the competitive procurement of renewable energy program of Duke Energy Carolinas LLC had been improperly eliminated from consideration. The petition was verified by Tim Lasaki. Did I get the pronunciation correct, Mr. Lasaki? Got it. He is the Vice President of Origination and Finance for Orion. Certain information within that verified petition was designated as confidential and has been so indicated in the clerk's records. On April 9, 2020, the independent administrator of the Cpra program, Axion Group LLC, which I will refer to as Axion or sometimes the administrator, filed a response to Orion's verified petition. That response was not sworn under oath. On May 26, Orion filed a reply in support of the verified petition. And on May 29, 2020, the public staff of the Utilities Commission filed a motion for leave to file comments, along with unsworn comments containing certain pages designated as confidential, along with an exhibit number 1, which was also designated as confidential. On June 12, 2020, Axion filed an additional reply to the verified petition. That reply was also unsworn. In accordance with the General Statute GS 62 15D and Commission Rule R1-19E, The public staff's right to intervene in this action and participate herein is recognized. On October 21, the commission accepted the public staff's comments, granted the motion, and accepted the comments and the exhibit. No other parties have intervened in this matter. However, on October 21, 2020, the commission ordered the joinder of Duke Energy Carolinas as party to the proceeding in order that certain evidence may be obtained, if necessary, from Duke Energy Carolinas pertinent to the issues in the proceeding. The commission's October 21 order further scheduled this hearing for this date and time via a remote means for the purpose of receiving testimony regarding the facts and circumstances of the evaluation of Orion's proposal following the time that it was submitted for evaluation. I want to make a few points on the record in light of the fact that we are conducting the hearing remotely. And I understand, unless I hear objection otherwise, it's my understanding that the clerk's records reflect that all parties have consented to the remote hearing. If not, let me know, please, now. All right, by the way of an access link provided on the commission's website, each of the parties has consented. And the interest of ensuring efficient use of the hearing time and minimizing the potential for technical difficulties, the commission has provided an opportunity for the parties to verify that they are able to access this remote hearing using technology provided by the commission for the hearing, including the offering of technology checks to all the parties in advance of the hearing date. We have further requested that the parties connect to the remote hearing 30 minutes prior to going on the record in order to check connections throughout the course of the hearing. The link will remain live, so you should have no problem rejoining the hearing if you are disconnected. Your link will still be live. You'll come right back into the meeting if you get disconnected in the same way you initially joined. Although we are connected through the video conference and we are not in the hearing room, it is the commission's expectation that the hearing will be conducted as if we were present together in the hearing room. And this means that we must maintain order and not interfere with the court reporter's ability to transcribe the hearing accurately. To that end, just a few housekeeping reminders about the remote hearing procedures. When you are not speaking, please keep your microphone on mute in order to avoid feedback. If you are not participating in the examination or cross-examination of a particular witness, if you're not the witness or you're not participating in the examination or cross-examination of that witness, please turn off your video. That will make it easier for me and for the other parties to keep track of those who are participating in a particular examination. If you need to be recognized or you need to interrupt for an objection or any other good reason, please let me and the court reporter know your name before you launch into your intervention. If you're going to be using a potential exhibit, please, for the benefit of everyone on the hearing, state the name of the exhibit, or its title, or how it's customarily referred to. Give the date of the exhibit as it appears in the list of potential exhibits filed prior to the hearing in order to enable everyone to locate the document. We will then mark the document for identification in the record, and that needs to be done before you ask any questions about the document. I would caution the parties that the admission of any live testimony in the record in this docket will not automatically bring into the record any exhibits that may have been discussed or referred to in that live testimony. To the extent the parties wish to rely on exhibits and have those made part of the official record, those exhibits must be identified, designated, and moved into the record by the sponsoring party in accordance with the commission's practice. Also, due to the fact that the hearing is being held remotely, in the event that a party must reference confidential information, we will leave the video conference and we will join a private teleconference line. Let me ask the counsel for the parties and on behalf of themselves and their clients, do all of you have the private conference line dial-in information? Has that been provided to everyone?
Yes, we do.
We do.
Okay, great.
Yes, we do. Thank you.
The party whose confidential information is being discussed is responsible for ensuring that only those who have executed confidentiality agreements are on the teleconference line. When discussion of the confidential information is complete, we will then leave the teleconference line and we'll go back into this video conference. Let me say, I know that there is confidential information that the parties have designated. I believe it might be possible to get through this hearing this afternoon without specifically referring to anything that is confidential. There are numbers related to Orion's bid and to the evaluation of Orion's bid that I know are confidential and have been marked as such in the record. However, it may be possible to talk about those numbers without actually sharing the numbers themselves. So if you can ask a question and give an answer without referring to any of the confidential numbers, we're going to try to, as best we can, to do that. At this point, let me call upon the parties to announce their appearances, and we'll begin with the applicant Orion, or the petitioner, I should say, Orion.
Good afternoon, Commissioner Clodfelter, Commissioner Duffley, Commissioner Gray. My name is Ben Snowden. I represent Orion Renewable Resources, LLC, the applicant.
Thank you.
Hello, everyone. This is Tim Lasowski. I'm here also for Orion Renewable Resources, LLC.
Thanks. Mr. Lasowski, you are appearing as a witness and not as counsel, as I understand it, correct?
Correct.
Right. Let me just ask counsel to announce appearances, and we'll hear the witnesses when they're sworn in. Mr. Higgins, I think you're probably next.
Thank you. Good afternoon, Commissioners. Dan Higgins for the ASEAN Group.
Right. Mr. Crisp? Can we get your appearance for the record, Mr. Crisp? You're on mute. You're on mute, Mr. Crisp. We can't hear you, Mr. Crisp.
Come on, close your meeting. I don't know what to do.
Just join.
Where? Sherry?
We can hear you now.
Commissioner, they're unmuted.
Mr. Crisp, would you announce your appearance for the record, please?
Yes, we seem to have lost our video. I apologize.
We can see you fine.
Oh, that's good. Attorney Jack Crisp, appearing for Axion Group.
Great. Again, Mr. Crisp, as I stated before we opened the hearing, we have a motion for your appearance pro hac vice in this proceeding. That motion has been granted, and you are authorized to appear pro hac vice for this proceeding.
I appreciate the commission's consideration. Thank you.
Thank you. Mr. Jirac.
Thank you. Good afternoon. This is Jack Jirac, Associate General Counsel on behalf of Duke Energy Carolinas, LLC.
And Mr. Dodge.
Good afternoon, Commissioner Clodfelter, Commissioner Gray, Commissioner Duffley. I'm Tim Dodge with the public staff. Also appearing with me is Layla Cummings.
Thank you. Any other parties need to announce their appearances? All right, thank you. Let me say a few words about the scope of this hearing. We really want this to be a fairly focused inquiry. We have your papers and your submissions that were filed prior to the hearing. You may assume that the panel has read those written submissions. Now, some of those are unsworn, so I'll need to rely upon counsel to the extent you want the commission to rely upon those in making its decision. You will need to, at the appropriate point, you will need to move for those to be admitted into the record as statements to the extent you need to offer those as supplemental statements to supplement your oral testimony given this afternoon. The commission's focus initially, when we noticed the hearing, was on what happened to the Orion proposal in step 2 of the evaluation process during tranche 1 of the CPRA program. As a result of some late filings, there may now be a somewhat different take on what the issues are going to be. So we'll hear you on whatever you want to tell us this afternoon. I'm not going to artificially limit you, again, because there seems to be some new information in the latest filings. But I would ask you again, you do not need to repeat things that you've already put into the record by sworn testimony. In the normal course of the proceedings, we would ordinarily hear first from Orion, followed by the independent administrator, then by Duke Energy Carolinas, and lastly, the public staff, and then come back to Orion for any rebuttal testimony. However, given the circumstances of this limited hearing, we have suggested to you through counsel that it may be most efficient if we change the order of presentation and instead commence with a presentation from the independent administrator, then move to Duke, the public staff, and lastly, give Orion a chance to offer rebuttal. I say that in part because Orion's petition is verified, and so we do have the verified petition in this case. Let me inquire, however, before we launch off in that direction, whether any of the parties have any objection to proceeding in that manner.
Orion has no objection.
Thank you.
Axion has no objection.
Thank you.
No objections from Duke Energy Carolinas.
Great. Thank you.
No objection from the public staff.
Fine. Mr. Snowden, even though your materials, pre-hearing materials are verified, I think for good order's sake, when we get to you, I will ask you, even though it will be on rebuttal case, I'll ask you to move the admission of your exhibits and your sworn testimony at that point, just so for purposes of having a complete record, we get those materials officially into the record. I can do that now, or I can wait and do it in your rebuttal case. I don't think the sequence really matters.
Yes, sir. We can do it on the rebuttal case.
That's great. Let me also advise the parties, you have submitted lists of proposed exhibits that you may use during the hearing. I know that I have those lists here, but let me advise you, just because we've can get this out of the way and you may not need to handle as much paper, the panel proposes to take judicial notice of the following documents. So you do not need to move these into evidence unless there is some objection. The panel proposes to take judicial notice of these documents: the request for proposals for tranche 1 of the CPRE program. That was not filed in this docket, but it does appear in docket SP-9590 sub 0 as attachment A to a pleading file March 13th, 2020 by Stanley Solar. It's in a different proceeding, but it is the request for proposal for tranche 1. The commission proposes to take judicial notice of that. The commission also proposes to take judicial notice of the independent administrator's April 9, 2019 conclusion report on the conclusion of the step 2 evaluation in tranche 1. And that was filed in docket E7 sub 1156. That is the docket for Duke Energy Carolinas on the CPRE program. The panel also proposes to take judicial notice of the independent administrator's final updated report filed on July 23rd, 2019, on the results of tranche 1 of the CPRE program. That was also filed in docket E7 sub 1156. If there's any objection to the commission taking notice of those 3 documents, I'll hear you now. If not, you can rest assured that those will be record, and you do not need to separately move the admission of those items as exhibits. All right, hearing no objection, let me ask the parties, are there any other preliminary motions or other matters we need to take up before we begin the evidentiary presentations?
None for Ryan, sir.
Okay. All right, then with that, Mr. Higgins and Mr. Crisp, I'll turn the matter over to you.
Thank you. Greetings from New Hampshire, where we're getting snow flurries today.
It's bright and sunny here in Charlotte. It's bright and sunny.
Glad to hear it. What I'd like to do is introduce the witnesses for Axion and have each of them in a very brief statement, give their background to the commission. And then I would like to have Mr. Judd offer some comments regarding two particular issues that I think are of importance. And then we would simply like to take questions from the commissioners.
So, Mr. Crisp, will you be offering the witnesses all at the same time, or do you tend to take them up sequentially?
We're going to do it as a panel, if that is satisfactory to you.
That's great. Well, then let's get them all sworn collectively. So will you call their names? And if your name is called as part of the Axion panel, will you please raise your right hand so I can administer the oath to you?
Harold Judd.
Okay. Mr. Judd, I see you.
David Ball.
Mr. Ball, I see you.
Philip Layfield.
Mr. Layfield, I see you.
Ralph Monsalvage.
Mr. Monsalvage, I see you. All right.
One more, Gary Rosier.
Keep your hands up, Mr. Rosier. You are not on my screen, but I see that you are in attendance. I see you now. All right. Will you take the oath now, please? Do you and each one of you solemnly and sincerely affirm that the testimony you are about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay. Madam Court Reporter, let the record reflect that all witnesses took the oath and gave the affirmation. All right, Mr. Crisp, you may proceed.
Thank you. The way I would like to start is just for each of our panelists to give a very brief background for the benefit of the commissioners so they will understand the qualifications of these individuals. Beginning by Mr. Judd.
Good afternoon, commissioners. Pleased to be with you again, even though it's remote. I am Harry Judd. I'm the independent administrator of the program. I started in the electric utility field as a state consumer advocate back in the, I suppose I should be embarrassed to say, back in the late 70s. Since then, I served as an energy counsel in the White House. I served in the solicitor's office at the Department of Energy, and I was a senior assistant attorney general for a state where I represented the Public Utility Commission, among other agencies. In 2000, I co-founded Axion Group. Since then, we have served as independent evaluator, or in this case, independent administrator, of over 100 solicitations for commissions across the country. We have done so in 20 evaluated power supplies from 23 different states and from 3 different countries. We were honored to be selected to be your independent administrator, and we're pleased to be here today to address this issue. Thank you.
Thank you.
Next, I'll call on David Ball.
Hello, I'm David Ball. I have an undergraduate degree in economics and a master's in business administration, and over 40 years of experience in the electric utility industry with economic analysis as my primary focus.
Thank you, David. Phil Layfield.
Mr. Layfield, you are muted. You will need to unmute yourself. We're not able to hear you, Mr. Layfield.
Why don't I move on to another panelist, and in the meantime, maybe Phil can get his audio going, since he appears to be muted at the moment.
All right.
The next is Ralph Monsalvage. Apologize, Ralph.
Oh, quite okay. I'm Ralph Monsalvage, and I've got approximately 35 years worth of utility experience, 22 years in generation planning, cost and benefit modeling, And with respect to academics, I have a master's in electrical engineering.
Thank you, Ralph. And last, Gary Rosier.
Mr. Rosier, you are also on mute.
Thank you. Good afternoon. Commissioners, I worked 45 years at Southern Company in roles in system planning, integrated resource planning, power procurement, power sales, certifications, a lot of appearances before every one of the retail operating company public service commissions in that role.
Thank you, Gary. Phil, let's try you again.
Until muted.
Phil, we're still not able to hear you.
It's not working.
Commissioner, would it be, this is Harry Judd, would it be beneficial if I simply stated Phil's background?
That would be fine. Let's make sure that he has if he's trying to use a dial-in number for the audio connection, if he's trying to use a phone, we may need him to check with John McCoy to be sure he has the correct phone number.
It appears, Commissioner, that he is attempting to join by telephone.
It appears that he is as well, but somehow that's not coming through. I'm not sure whether he has the right phone number or not.
Well, I'm going to suggest again that I simply state Phil is our lead transmission analyst and has worked across the country as well as internationally on system designs for transmission and distribution systems. He worked through Tranche 1 and Tranche 2 with us, as well as has worked with us across the country for the better part of 20 years. You can tell by the hairline that he's been at this a long time.
Likewise.
Phil, if you're able to hear me, I'd like to suggest that you get in touch with John McCoy to make sure you have the correct number to dial in if you're going to try to communicate by phone. All right. Moving along, the memo that we received from Attorney Hicks indicates that there are 3 questions that the Commission is primarily concerned with. In an effort to move this along as efficiently as possible, I'm going to try to address each of those questions. First is whether the proposal was evaluated by the DEC T&E team, and if so, under what processes and standards. The answer to that question is that it was evaluated by the DEC T&E team. The evaluation was done after Axion had mistakenly requested security from Orion, and it was done without Axion's knowledge, and the information was never shared with Axion. So you can inquire of Duke as to what their team did, but that is what happened. What resulted from the DEC T&E team's review of the proposal in step 2, since it never reached Axion, as far as Axion's concerned, nothing ever happened with it. How the results of the DEC T&E team's review were then used by the independent administrator in its final evaluation of the proposal. And since the information never arrived to Axion, it was never used by Axion in its evaluation. And that's the answer to those 3 questions.
Mr. Judd, I need to ask you, since you are the witness, whether you adopt your counsel's summary of the statement as your own testimony.
I do, sir.
All right, very good.
And what I would next like to do, unless, sir, you have a question of Mr. Judd, I think that one of the important considerations here is having a clear understanding of two terms that are being used in this situation. One is net benefit, and the other is avoided cost. And I'm not suggesting that the commission is not familiar with those terms, but I think it's important to have a clear understanding of their meaning in the context of this particular project and in terms of the Axion methodology. So I will ask Mr. Judd to address that particular issue.
Thank you, Commissioner. As Attorney Chris said, we understood, going beyond the three questions that were laid out for us to address, that the issue before the commission is how should aborted cost be defined for purposes of CPRA. And that is, should it be the net benefit to customers based on a detailed hourly analysis over the 20-year PPA contract for the CPRA context, or if a different definition should be used. And as we said in our initial pleadings, we will welcome the Commission's guidance on how to proceed. In the CPRA program, we rank bids using the pricing and the hourly production profiles provided by the bidders, and then we compare that with the hourly avoided cost data that we received from Duke for every hour of every day for the 20-year period. Now, that was different than the guidance given in the RFP and on the bid form, but I think it's useful for the commissioners to understand that we did an hourly analysis, 8760 times 20 years. In doing that, our goal was to meet the requirements that all the bids that we selected and recommended to do for contract are at or below the Duke's forecast of avoided cost for the entire 20-year period. The statute, the relevant statute here for CPRA, does not require Duke or the IA to select each and every bid that is presented as being below avoided cost, but rather we understand our role is to seek the least cost alternative for ratepayers. We understand that the 20-year avoided cost projections that were provided to us by Duke are in keeping with the Commission's approved methodology as required by the statute. Further, we understand that in identifying the least cost option for customers, that is the least cost compared to the alternative, which was the avoided cost defined by Duke. As noted, we used the data provided by the bidders. I think the commissioners might appreciate that what we required of bidders was an 8760, that is the hourly data for every year of the 20 years. We didn't simply take 1 year and extrapolate, but rather we said, you tell us what you think your production profile will look like for the entire term. Therefore, we were able to compare that and align it with the data we received from Duke. To doing that produced the net benefit. That is the calculation of the cost of the bid compared with avoided cost for the entire year. And that net benefit is synonymous with the terms avoided cost as it's used in the electric utility industry. Putting a little finer point on it, a positive net benefit provides savings for the customers all, and a negative net benefit does not provide that benefit. We've used this methodology, this industry recognized standard, as I noted, in over 100 RFPs across the country, including—
Commissioner Clodfelter, I'm sorry, this is Ben Snowden from Orion.
Yes, Mr. Snowden.
Okay, I'd like to object to Mr. Judge's testimony at this point. The commission noticed this hearing to address certain specific factual issues, and Mr. Mr. Judd appears to be taking the opportunity to offer additional argument beyond what was contained in the briefs. Thus far, he's been discussing and trying to clarify, I think, issues that were previously discussed in the briefs and in the IA's filings, and I have not objected, but Mr. Judd appears to be going into entirely new territory with this this discussion.
Mr. Crisp, do you want to respond?
I think that the two critical issues that the commission is wrestling with, or may be wrestling with, or is certainly considering, are net benefit and avoided costs. And I think Mr. Judd is trying to explain to the commission exactly how those terms were utilized in their review and analysis of each of the bids, including Orion's. And I think that the explanation will be of benefit to the commission if Mr. Judd is allowed to conclude. And I will assure the commission that he is almost done, because I know exactly what he has left to say.
Let me tell you what I think we need to do here. Mr. Snowden, I appreciate your objection, but in part we're having this hearing. We asked the parties to address some very specific questions, and that is correct. But we also having this hearing in part because a lot of what we had was not sworn testimony in the record, and we needed to be sure we had it under oath before we started making decisions based upon that. So I'm going to allow Mr. Judd to complete his answer. I'm going to give you similar latitude, of course. Again, your testimony was put in a sworn form, but I'm going to give you similar latitude when we get to you. I think Mr. Judd has answered the specific questions we wanted to explore, but again, he's also talking about matters that were covered in the pre-hearing unsworn filing, so I'm going to let him conclude that.
Thank you, Commissioner. As I said, we used net benefit and avoided costs synonymously. In tranche one, the Orion bid, as was presented in our filings already, was ranked last of the 55 bids. In tranche two, Orion again bid the project and was awarded a PPA on October 15th of this year. If the tranche two executed PPA is replaced with a contract using the pricing that was bid in tranche one, there will be significant increase in total cost to customers. No, I'm not going to.
Commissioner Clodfelter, I'm sorry, this is Ben Snowden again.
Mr. Snowden.
I apologize. I will object again. This is definitely going beyond the scope. No. Orion's participation in tranche two is a matter that is outside the scope of any of the filings so far in this matter. If the commission has questions regarding Orion's participation in tranche two, we're happy to have that discussed at this hearing. However, we would ask if we go into those issues that would be allowed to, excuse me, to file a supplemental response if it's necessary. Mr.
Snowden, I am going to let Mr. Judd just finish out the current answer. I think he's almost done, but I think it's a pertinent topic because when we get to your case, I think we will have some questions with you about how the outcome of tranche two might come into play in this proceeding. So
thank you.
We're going to give you a chance to address the topic as well.
I would only add that it is relevant since it relates specifically to the remedy that they're asking for. So I think Mr. Judd is done.
I am, Commissioner. Thank you.
The last thing I would like to do is ask that the written submissions that were not under oath be admitted as exhibits or considered submitted. I don't know the appropriate terminology in North Carolina, but we would like to have them fully considered. And Mr. Judd is the author of each of those filings.
Mr. Crisp, I have several of those that we referred to in the opening statement, and so we're going to need to identify those for the record and get them designated. The first of those would be, let me retrieve my notes from that.
It would be the independent administrator's response to the verified petition. dated April 9th.
And that was dated
April 9th.
9/2020. All right, it will be designated as Axion Exhibit 1 for purposes of this proceeding.
Then there is the independent administrator's response to an additional reply by Orion, and that is dated June 12th, June 11th.
All right, and that document then will be designated as Axion Exhibit number 2. Again, these are matters that are of record in the clerk's office, Ms. Mitchell, so we'll be able to retrieve those from the clerk's docket and get them appropriately designated in the record, okay?
And then there's a confidential attachment filed in October 28th.
All right, and that is the submission made on October 28, 2020, and that will be designated as Axion Exhibit number 3. Okay.
And at this point, hoping that Mr. Layfield has resolved his audio technical problems, I am prepared to entertain questions from the commission so that it can get the information and the answers it needs, make a fully informed and appropriate decision.
Let's see if we have Mr. Layfield back with us. Mr. Layfield, can you hear us?
I see him, I see his name here. I don't know what that means, but we're certainly prepared to go forward whether he is able to join us or not.
All right, well, it appears he is having, again, difficulty with the audio. All right, let's proceed then, and hopefully we'll get Mr. Layfield with us shortly. Let me ask the other parties, are there any questions for this panel? Mr. Jurak, do you have any questions?
I do not have any questions at this time, Commissioner.
I'm going to go a little bit out of order, Mr. Dodge, because of the odd procedural posture we're in here. I'm going to take you next rather than last. Does the public staff have any questions for the panel?
We do not have any questions. Thank you.
All right. Mr. Snowden, we're with you then. Any questions for the panel?
Yes, sir, I do. Okay, and I guess I will address these questions to the panel where, in general, and if I have questions for a specific witness, I'll address the specific witness. So can you all confirm the Orion proposal was advanced to step 2 of the Cpra tranche 1 process? We established that, is that right?
Yes.
And they posted their $1.488 million in bid security to advance to step 2?
Subject to check on the number, that is correct. They did post bids security, proposal security.
Thank you. And under the terms of the RFP, the step 2 analysis was intended to determine the upgrade costs that would be associated with each proposal. Is that right?
Yes.
And that analysis would be done by Duke's transmission and distribution evaluation team?
Yes.
And that would be done in the grouping study. Is that right?
Would be done in the DEC's T&D team's approach. You know, Ben, that we've had some discussion in the stakeholder sessions and otherwise as to when a grouping study is required. So if you want to go deeply into that, we certainly can, but it was to be evaluated by the T&D team.
Thank you. And it was necessary to determine a project's upgrade costs in order to rank the CPRA proposals in terms of their total value to ratepayers. Is that right?
I'm sorry. I don't think that is correct. It was we did our evaluation and our ranking in step 1. If it was evaluated in step 2, identified system upgrade costs would be imputed and provided to the IA for a re-ranking. But as you know, it was not re-ranked because we did not receive any system upgrade costs from a step 2 analysis.
Understood. I'm sorry, I'm speaking generally. In that re-ranking that you mentioned, the T&D system upgrade costs were part of the data used to do the re-ranking. Is that right?
For those proposals that were reviewed in step 2 and the data provided back to us. Yes. I don't mean to be semantical, Ben, but you know, there were a whole lot of bids that dropped out and they weren't ranked either. So beyond step 1.
Thank you. And the re-ranking for the projects that were re-ranked would be done by the independent administrator using the information on upgrade costs provided by the T&D team. Is that right?
If I understand your question, when a step 2 analysis was done and the data provided to us, we would then re-rank the bids, yes.
Using the information, in addition to using the information generated by the IA, you'd also use the system upgrade costs provided by Duke. Is that right?
Yes.
Okay. And calculation of upgrade costs was also necessary to determine whether particular bids exceeded the awarded cost cap, wasn't it?
I don't agree with that statement. As you know, if it wasn't evaluated, we didn't use the data.
Okay. You did say earlier, didn't you, that when you were, Mr. Crisp was asking you questions, that the independent administrator used net benefit and avoided cost synonymously. Is that right?
I did state that, yes.
Okay. And you're aware, though, that the Commission's rules on CPRE state that avoided cost is to be assessed by reference to the published avoided cost rate. Are you?
I couldn't understand your question. You kind of broke.
Okay, sorry. Okay. You're aware that North Carolina, I mean, I'll back up. You stated that you use net benefit and avoided cost synonymously because that's how you had employed those terms in previous RFPs. Is that right?
In other RFPs and in this one, yes.
Okay. But you're aware that North Carolina has its own definition of avoided cost for purposes of CPRE, are you not?
It's our understanding the definition is the avoided cost for the 20 years that use the methodology for determining avoided cost that was approved by the Commission. That's the data that we used.
Okay. So are you aware that, or would you agree that the Commission rules provide that avoided cost is to be assessed relative to the published avoided cost rate?
I candidly, Ben, don't know the difference between what was approved by the Commission and what was published. And I think perhaps you can help with the definition. Again, the data provided by Duke that was, we understand, calculated using the approved methodology.
Understood. So when you say the data provided by Duke, you're talking about an 8760 20-year hourly forecast of avoided costs. Is that right?
Yes.
Okay. But that data, those hourly data, are not published, are they?
I can't answer that. I don't know, Ben.
Have you not stated in the past that it would be inappropriate to make that data available to bidders because it would allow bidders to game the system with their bid construction?
We have supported Duke's position of not releasing that information. The 8760. Oh,
I'm sorry. I think there's an extra microphone on somewhere. I'm getting a lot of feedback. Could you please restate your answer?
Okay. I understand the question to be whether we understood that the 20-year 8760s were published. And the further on the question was, had we said that we did not support releasing that data because that was Duke's position, because it could be used to game the system in providing production profiles that matched up with that information. And yes, we did take that position, and the buckets, if you will, in tranche 1, there were 3, there were 9 in tranche 2, were a compilation of many periods reduced to provide guidance on avoided costs for a limited number of pricing periods.
So you're aware that the 8760 hourly data was not made public to bidders, is that right?
You know, Tim, I'm sorry, Ben, I'm not certain of that because I'm never certain of what information has been released under protective orders of the commission, because I do know that data that is provided confidentially can be provided to parties who execute confidentiality agreements. So it was not published as part of the RFP though, and it was not published on our website and made available to all bidders. Again, I'm not trying to be difficult. I'm saying I don't know what each of the
understood. Thank you. But your understanding is that it was not made generally available. Is that right?
It was not made available as part of the RFP. That is correct.
And the published avoided cost rate is, as the name suggests, a published rate. Is that right?
I would hope so, yes.
Okay, so those are two different things, aren't they?
They may or may not be, Ben. Again, the definition of what's published as opposed to what is released as confidential information, I suggest you might ask counsel for DEC or someone who does more practice before this commission.
But you don't disagree that there is such thing as a published avoided cost rate?
The terminology is out there, so there must be, yes.
Okay, thank you. So going back, you indicated previously that Orion's proposal was erroneously advanced to step 2. Is that right?
That is correct.
And it's your understanding that DEC did in fact include Orion's proposal in the step 2 analysis, but you never received the information?
Actually, Ben, I was premature in my answer. Permit me to correct. They were asked to post proposal security, as were others. And that was the error. We should not have asked for the proposal security. They were not advanced to step 2. We did not ask the Duke T&D team to analyze the proposal.
Okay, I'm sorry, I must have misunderstood. I thought you testified a few minutes ago that Duke did in fact conduct a step 2 analysis of the proposal, but that you never saw the results. Is that not your testimony?
Well, I believe that counsel said that, but we were told subsequently that in anticipation of the proposal being submitted to the step 2 T&D evaluation, that the T&D team had done some preliminary review. We did not ask them to do that. We advised them that we had requested proposal security, which was in keeping with our practice that for all proposals, when we asked for proposal security, we advised the T&D team so they could isolate, if you will, those particular projects and have them teed up for review. But we did not ask for it, and we did not receive that information during our tranche 1 evaluation.
So you informed Duke that the project had posted its proposal security, is that right?
No, sir. We advised them that we had requested the security. We did not advise them that it had been posted.
Okay. Did you advise Duke to withdraw the project from the step 2 T&D evaluation?
We didn't ask them to include it, so therefore, no, we did not ask them to withdraw it.
Okay, so you never received any information about system upgrade costs for the project from Duke?
Not exactly. We understood that there was a baseline cost that any project coming in at T&D level, at transmission level, would incur. And that was a blanket across the board. It was not specific to that proposal.
And what was that baseline cost?
Approximately $450,000.
And you received that information from DEC, is that right?
Yes.
Okay. But that was not specific to the Orion project, is that right?
That is correct.
So to your knowledge, no determination of the system upgrade costs associated with the Orion project was made by Duke?
I didn't say that. I said that it wasn't shared with us. So I think Mr. Piper is a witness, and I think he can tell you what they did. I can tell you what we knew and when we knew it, but I can't, he's not my witness. I can't testify to what he did.
Understood, thank you. What did you know and when did you know it?
Howard Baker lives on. Again, oh boy, you're asking the date on when we learned that?
Approximately. The precise dates are probably not necessary at this point.
Mr. Ball, do you remember? I don't. Because again, we didn't ask for the evaluation. My memory is it was after we had concluded tranche 1, but perhaps someone else on the panel recalls.
This is Dave Ball. Judd, I think you're asking the evaluation cost estimate for Ryan and tranche 1.
You're breaking up, David. Could you repeat?
I'm sorry. Is the audio okay now?
Better.
I clarifying the question to be, when did Axion?
Mr. Ball, our court reporter is still having trouble with you. Still having trouble hearing you.
I apologize. It all checked out fine on the audio test. Okay.
I think, excuse me, just 1 second. I see several people are unmuted, and I think that's the problem.
Yeah, again, if you are not speaking, please put your microphone on mute.
Okay, thank you. Can you hear me now? Thank you. I think just wanted to clarify that the question was, when did Axion receive the Duke T&D evaluation for Orion's tranche 1 proposal? Is that the question?
That will do. Yes.
And I have general knowledge of that. It's not my technical area. Mr. Layfield is the T&D person, but I think the answer is well past the conclusion of tranche 1. And I'll mute.
Okay, so Mr. Ball, Axion did ultimately receive a calculation of upgrade costs for the Orion proposal?
Like I said earlier, that's not my area of expertise. Mr. Layfield could answer that, but I do know it was well past the conclusion of tranche 1, and it may have been as recently as last month or two. I'm just not sure.
Okay, so you don't recall specifically whether Axion received information about the tranche 1 step 2 analysis for the Orion proposal?
I do know that we did not receive the tranche 1 step 2 cost estimate for Orion during tranche 1.
Understood. So just to be, I apologize if I'm going over this ad nauseum, but just to be clear, I guess this question would be for Mr. Judd. It's your understanding that Duke would not have included the Orion proposal in the step 2 analysis because you didn't ask them to?
Then they only included in step 2 analysis the bids, proposals that we passed over to them, and that's in keeping with the process. As you know, again, a number of proposals withdrew, didn't post proposal security. So we had to rank them. We provided them to the T&D team in rank order as we presented them. So I believe that's responsive to your question. If you want to try again.
Just one follow-up. So you did not pass on the Orion proposal to DEC to be evaluated. Is that right?
That is correct.
Okay, thank you. And why didn't you?
Because we determined that it was net negative for a benefit, that it would cost customers more than the long-term avoided costs provided to us by Duke.
So when you say it was net negative, you mean that the value of the project was negative relative to that 8760 20-year hourly avoided cost projection? Is that right?
It is. And as we stated before, we should not have asked them for proposal security. That was an error on our part.
So you did not evaluate the project's bid price relative to the published avoided cost rates. Is that correct?
I'm sorry, I'm not understanding your question.
Okay. Well, returning to the Duke's or DEC's published avoided cost rates, if I understand you correctly, you did not evaluate whether the project's bid price would have been above the published avoided cost rates. Is that right? With inclusion of system upgrade costs.
Yeah, respectfully, I think we've gone over this and the witness has answered this previously.
Well, Mr. Judd has testified to what he did do, but I just want to, I'm for one, still a little bit unclear, and just want to make sure I understand that what he did not do. So I will make this very concise.
Yeah, he's indicated that he is unfamiliar with what the published rate was, so I don't think he can answer that question.
All right, let's see if he can answer the question. Can Mr. Judd, if you can answer the question, please do so.
Commissioner, I stated what we did, and now I'm being asked to identify what we didn't do. Is that, you'd like me to answer that?
If you can do so.
We used the data we were provided for the 8760 for 20 years. I'm not able to say whether that information was released to prospective bidders. I can say we did not provide it, we did not post it on the website that was used for bidding, and whether they received that information otherwise, I'm sorry, sir, I'm not capable of addressing that. So,
all right, thank you. So, and Mr. Judd, Mr. Crisp indicated that you were not familiar with the published avoided cost rates. Is that accurate?
I think, Ben, I've said the distinction between the published and what was available to bidders is beyond my knowledge.
Okay.
I know what we used and I know how we did it. And I think we've accurately described the evaluation methodology that we used.
Okay, thank you. And Mr. Judd, you understand that the published avoided cost rates are included in pages 11 and 12 of the RFP document?
It's subject to check on the pages. And I trust you're talking about tranche 1 RFP. I know that we published information on avoided cost as guidance to the bidders. Yes.
So you certainly had access to information about what the published avoided cost rates would have been?
I had access to what information was being provided. Again, I'm not comfortable with identifying and defining whether that was the published or it was otherwise advisory information.
I'd like to ask for clarification. If Attorney Snowden, you're equating avoided cost figures that were provided in the RFP as published, that's what you mean. By virtue of their being in the RFP, they were published. You can clarify that.
Sure. I'll ask one final question on this, and that'll hopefully clarify.
I'd like to know if that's what you mean.
Okay. Yes. Thank you. So, Mr. Judd, if I understand it correctly,
I think we need to clarify that because it seems to me that there's a real, at least for me, there's a real ambiguity here. What is it you mean by published rate? Are you referring to what's in the RFP?
Okay, yes, but I'll just ask the question in another way and hopefully that'll clear it up. So Mr. Judd, am I correct in my understanding that you did not, that in deciding to release the Orion proposal, you did not consider whether Orion's bid price, inclusive of system upgrades, would exceed the avoided cost rates that are included in the RFP document?
Correct.
Thank you.
Because we did not have the system upgrade numbers.
Perhaps I could add a clarification on that to help you, Mr. Snowden.
Please, Gary, go ahead.
We're talking avoided cost rates that are published, as you say. I'll take your word for what that means. Those are in 3 buckets that take a great deal of data, 8760 over 20 years, present value, constructing at what you call a published rate. What Axion used was essentially a deconstructed part of that went from where all those numbers began to roll up into that overall published rate.
Understood.
So they're not inconsistent in being the avoided costs of the company.
Understood. Thank you.
Thank you, Gary.
So Orion was notified in April 2019 that its proposal had been released. Is that right?
Its proposal or its security?
Its proposal had been released from CBRE Tranche 1. If I'm using the wrong term, please correct me.
Subject to check on the date, yes, they were notified.
Okay. But Axion did not inform Orion when they were released why they were released, did it?
I'm sorry, Ben, the beginning of your statement was...
I'm sorry. Axion did not inform Orion when they were released why their proposal was being released, did it?
That is correct. We did not.
Okay. But Orion did ask for more information about why they were released, didn't they?
Yes.
And on April 9th, 2019, Orion specifically asked the IA to confirm the accuracy of the T&D upgraded costs assigned to the project, didn't they?
I'd have to check the record. Sorry, Ben, I don't have the chronology in front of me.
Thank you. Understood. I'd like to, Commissioner Klinefelter, I would like to have marked for identification petitioner's first cross-examination exhibit. This would be the document dated July 15th, 2019, DEC Tranche 1 message board. And it consists of 15 pages with sort of alternating white and gray rectangles. And at the top, it says your conversation with DE administrator.
The document will be marked as Orion Axion Cross-Examination Exhibit number 1.
Thank you.
I'm sorry, Ben, could, just to make sure I'm looking at the same document, is that the one that has, what is the first date stamp on it, please?
The first date stamp is 7/15/2019, and there's a heading that says your conversation with DE administrator.
11:28 a.m. Is that correct?
Yes.
Great. Thank you.
Okay. Thank you, Mr. Judd, or any of the witnesses in the panel. Do you all recognize this as a printout of correspondence between Orion and the administrator?
Yes.
Thank you. I'd like to direct your attention to, and I apologize that these pages are not numbered. I'd like to direct your attention to page 7, please.
Can you give us the pages?
Oh,
are-
sure. Page 7, it would be, the date stamp would be 4/9/2019. Just please tell me when you got that.
Oh, I have it open. Thank you.
Okay, thank you. So looking at the entry with the date stamp 4/9/2019, 8:32 p.m., it states here, and I just ask you to follow as I read it along. It states here that Orion has reviewed the final notification letter and read the IA Step 2 report. We believe there might be some misunderstandings or misallocations of the interconnection facilities costs included in our proposal decrement. Could the IA please confirm as soon as possible what T&D upgrade cost was assigned to our proposal? Do you see that?
I do.
Do you recall what the IA's response was to, or does anyone on the panel recall what the IA's response was to this request for confirmation of the T&D upgrade costs?
I believe it's the next item on page 7.
Okay. And what does that say?
We responded to Orion in the same way we did for all others. We treated all bidders in the same way, and that is we could offer up a debrief after the conclusion of tranche 1, which was, by definition, after the contracting period was finished. So we did offer to talk with them and to review what they had submitted.
So it does state here, the IA does state here that the step 2 process evaluated the transmission system impact of all CPRA proposals relative to other projects in the transmission queue, doesn't it?
I'm not seeing that language. Can you give me
Okay.
the reference?
Sure. I'm sorry. Looking at the last, the block with the timestamp 7/21/45 a.m. It says here, as discussed in the RFP and in other explanatory information provided on the IA website.
Next page.
Okay, yeah, we're on page 6.
Oh.
Sorry, yeah, the previous page.
Okay. Okay.
Sorry about that.
I'm still referencing page 7. Thank
All right,
you.
just tell me when it's the bottom entry. Do you see where it says the step 2 process evaluated the transmission system impact of all CPRA project proposals relative to other projects in the transmission queue?
I do see that language, and that refers to those that we refer to the step 2 analysis to be reviewed. Obviously, I suppose, could have provided more qualification there, and all CPRE proposals that were referred to the step 2 evaluation process, but we didn't. But that is clearly what
you didn't indicate to Orion that their proposal had not been moved to step 2, did you?
That is correct. It is correct.
Okay. And then looking up, sorry, on page 3 of the exhibit, the entry, it's date stamped 6/5/2019, 2:24 p.m. Just please tell me when you see that.
2:24?
Page 3 of this document. Yeah, 2:24 p.m. That's right.
2:24 p.m.
Mm-hmm.
Yes, I see the dispatch with a note from Tim. Mm-hmm.
Okay, and Tim, Orion here is making a follow-up request for information about the step 2 analysis, aren't they?
Yes.
Okay. And then looking to the top of the page, the IA responds and says here that in the first bullet point, sort of halfway through, it says network upgrade costs were calculated by the T&D evaluation team and were decremented from the dollar per megawatt value of each proposal in the competitive tier. Do you see that?
Ben, you're talking about June 6th at 10:34?
Yes, I'm sorry. Yes, the top block on the page. June 6th at 10:34.
I see that now.
Okay, so it says there that network upgrade costs were calculated by the T&D evaluation team and were decremented from the dollar per megawatt value for each proposal in the competitive tier. Is that right?
That is what it says, yes.
And Orion's proposal was in the competitive tier, wasn't it?
Yes.
And then it says that proposals were individually analyzed since there were no transmission interdependencies among any of the proposals in the competitive tier. Is that right?
That is what it says. Again, I've explained, we did not analyze a step, we did not have a step 2 analysis done for your client's proposal.
Okay. Understood. I guess these responses from the IA tend to suggest that to Orion that a step 2 analysis was done, don't they?
One could infer that, absolutely. We were speaking broadly and should have been more precise. Absolutely.
Understood. And so you all, Axion did offer to discuss the proposal, but not until after the contracting period was completed. Is that right?
Consistent with how we responded to all bidders who asked for a debrief after the fact, yes.
Okay, understood. And that discussion actually happened in August 2019, is that right?
I believe that was in August, yes.
Okay. And that was after contracting had been completed, wasn't it?
Yes.
Okay. And in communications with Orion while Tranche 1 was still pending, the IA never indicated to Orion that its proposal was eliminated based on the net energy benefit analysis, did it?
No. I'm not saying that we use that language, correct.
Okay. But the IA did inform Orion in August that its proposal had been eliminated based on the net energy benefit analysis. Is that right?
Yes.
And at the time, well, let me take a step back. Let's see. Mr. Ball, were you on a telephone call with Orion on around August 20th, 2019 to discuss the release of their proposal?
I don't have the date in front of me, but yes, Mr. Layfield and I conducted the debrief with Orion.
Okay, okay, thank you. And in that debrief, Axion informed Orion that they'd been eliminated based on the net energy benefit analysis. Is that right?
That's correct. We confirmed the information that we sent over to them in advance of the debrief session, which states that.
Okay. And did they disagree at that time that this was consistent with the rules of the Tranche 1 RFP?
They were not happy with that. I can recall that for sure. I don't know that about what you said as far as it complying with rules.
Okay. But you recall that they didn't think that it was appropriate that they'd been eliminated from the RFP?
Mr. Layfield, may I interrupt? Can you turn on your camera, please?
Commissioner, this is John McCoy. We are working with him right now. He's definitely having technical difficulties, so I think his video is off.
I apologize. I will leave it be. Thank you.
Okay.
Okay, thank you for that. Mr. Judd, well, anyone on the panel, you are aware that Orion contacted the public staff in October of 2020 to discuss the disqualification of the project. Is that right?
We learned that after the fact, yes.
Mm-hmm. And you're aware that Orion sent the public staff a letter regarding their disqualification or their release from Tranche 1?
That too, we learned after the fact, yes.
Okay. And you received a copy of that letter, didn't you?
We did.
Okay. And that letter specifically addresses Orion's concerns about the use of the net energy benefit analysis, doesn't it?
Yes.
So you're aware, okay, so you were aware at that time of Orion's specific concerns about the use of net energy benefit analysis to disqualify their project?
We were when we received the letter, yes.
Okay.
And I don't recall how contemporaneous to the date we received the letter.
Understood. Thank you. Did the public staff ask you any questions about the analysis that Axion performed on the Orion proposal?
Yes, and I believe you have our written response to the staff on that point.
Okay. Well, could you tell me generally what your response was?
That it was limited. We used the net benefit analysis approach, and because we found that it was negative net benefit. That is, it did not provide benefit to ratepayers.
Did you tell the public staff that the project had been eliminated based on a conclusion that it was above avoided cost?
We did, using our definition that avoided cost and net benefit were synonymous.
Did you tell the public staff that you had considered the cost of network system improvements for the project in concluding that it was above avoided cost?
We told them that we were aware of the $450,000 cost being assigned to, or would be assigned to all proposals coming in at transmission level. And yes, we were aware that that would be assigned.
And you're aware that Orion has asserted in its filings in this docket that based on its bid decrement, it could have accommodated interconnection or upgrade costs considerably higher than that $455,000, are you not?
I'm aware that's their position, yes.
Have you responded to that that assertion in any of your filings in this docket?
I'm sorry, in an email response?
No, in any filing in this docket.
I'd have to review what we submitted, Ben. I don't recall.
Mr. Snowden, let me interrupt your questioning for just a second to see if we have Mr. Layfield connected now.
It's quite possible that you'll be able to hear me now.
I think we can hear you now, and we can also see you now. Welcome back, Mr. Layfield.
I've had to change computers. I went down the street and asked my neighbor to bring his up, and now we're here. So I apologize for the difficulties.
You come back at an appropriate time. I'm sorry to interrupt, Mr. Snowden. You may continue.
Thank you. Mr. Judd, you indicated in your response to the public staff that it was determined that the Orion proposal would require $450,000 of network system improvements. Is that right?
As I've stated, we expected any project coming in at transmission level would incur that minimum amount of cost, yes.
Did you indicate to the public staff that number was not based on the step 2 T&D analysis?
I don't recall.
Did you tell the public staff that it was determined that the Orion proposal would require a minimum of $450,000 of network system improvements in light of a decrement bid? I'm sorry, let me rephrase that. Did you tell the public staff that in light of the decrement bid, the IA determined that imputing the costs of network improvements would result in the proposal being above avoided cost?
If the question relates to what's in the memo, and the memo is an exhibit, I mean, the memo speaks for itself, and having this witness testify as to what he recalled in terms of what's in the memo, seems like it's really unnecessary. If everyone has the memo is there and it says what it's.
Mr. Crisp, the problem we have at this point is the memo is not in evidence. So the question is an appropriate question. The memo is not sworn. It's not sworn evidence. So Mr. Snowden, may proceed with the
Thank you, sir. Yeah. And to be clear, I'm trying to avoid us having to go into confidential session.
I understand what you're trying to do. Continue.
Okay. Thank you.
Thank you.
Mr. Judd, did you tell the public staff that the IA oversaw the step 2 process, and as part of that process, an estimate of transmission system upgrade costs was established?
Excuse me, if you're referring to your client's proposal that we established a system upgrade cost for them, we identified the $450,000 baseline cost that would be incurred by any transmission level project.
Well, let me ask this again, and if I may do this without introducing the memorandum into evidence right now. But Mr. Judd, you have a copy of that memorandum before you, is that right?
Is that the one dated November 20, Ben?
Yes, sir.
Got it in front of me.
Okay, great. Thank you. And I'm looking at page 4.
I'm there.
Okay. Does it say sort of in the middle of the page that the IA oversaw the step 2 process? As part of that process, an estimate of transmission system upgrade costs was established. The Orion proposal was above avoided cost when the estimated transmission system upgrade cost was imputed. Is that what the IA told the public staff?
That is what it says, and that references the $450,000. Yes.
Okay. But there's no reference there to the net benefit analysis, is there?
There isn't. And in context, Ben, this was subsequent to a number of conversations with the staff, some meetings with them to discuss it. So we synthesized our response this way, did not include all the qualifiers one might do if we were viewing this as hostile questions. And they were already aware of our process. They had run the model with us that we used for net benefit analysis. They understood how it worked. They understood how sophisticated and detailed it was. So we didn't feel the need to revisit that, replow that field in response to these questions.
Thank you. But you were responding here to questions that Orion brought to the public staff. Is that right?
Yes.
And in the letter that you saw from Orion, Orion did specifically express concern about whether the use of the net benefit analysis was consistent with the rules of the RFP, didn't they?
Subject to check. I don't have that letter in front of me, but I believe that was raised. Yes.
Okay. Did you think it would have been appropriate to make clear in communications with the public staff when the IA was using the net benefit analysis and when it was using some other analysis?
The net benefit analysis is the only methodology that we use, Ben, and the staff was well aware of that.
Thank you. Did the IA ever provide either to the public staff or to Orion the details of its analysis or of the analysis by which it concluded that $455,000 in upgrade costs would put the Orion bid over avoided cost?
Ben, no, because since it was already net negative, any additional cost was not going to improve the bid. So we did not provide that to say, add an additional cost, it's going to make it worse. That was our reasoning.
Thank you. So just to be clear, you all never analyzed whether Orion's bid decrement relative to the published avoided cost rates in the RFP could accommodate $455,000 of upgrade costs before going over avoided cost.
Correct.
Okay, thank you. Those are all the questions I have. Thank you.
Thank you, Mr. Snowden. It's our practice to give our court reporter a break. She's the one working the hardest this afternoon. And so we're going to take a short break. But before I do that, I'm going to ask Mr. Crisp if you have any redirect of the panel that you'd like to ask before we take our break.
Can I consider that during our break?
I will allow the consideration during the break. Let's take it's 3:28. It's 3:28 p.m. Let's come back at 3:40 p.m.
Thank you.
And if you'll go on mute and stop your video while we're on break, please. Commissioner Gray, are you back with us?
Yes, sir.
Great. We seem not to have Mr. Judd and Mr. Crisp.
They were here a second ago.
They were indeed. There they are. All right, let's see, Mr. Layfield. Calling Mr. Layfield.
I believe I'm here.
We can hear you, and now we can see you.
Excellent.
All right, Kim Mitchell, are you ready to go? Okay. All right, Mr. Crisp, any redirect from for the panel?
None, thank you.
All right. We'll go then to questions from the commissioners. Let me ask Commissioner Gray, do you have questions?
I have no questions for this panel.
Okay. Commissioner Duffley, do you have questions?
No, Commissioner Clodfelter, I defer to you.
Okay. Let me ask just a couple, gentlemen. Mr. Judd, when you first began speaking, I made a note, and I wasn't sure I understood you correctly. And my note was to the effect that you said something to the effect that the net energy benefit tool that you used differed somewhat from what was described in the RFP. Did I get that correct?
I'm sorry, Commissioner, I think that might have been Mr. Rozier, but I'm happy to address, if I said it that way, then let me address it.
Well, it was part of the summary. It was part of the general summary you were giving. I'll take the answer from either you or Mr. Rozier.
Fair enough. Well, let me refer back because I did write it out to make sure that I didn't take too much of your time. I'm not, well, let me just say it this way, that, again, we used net benefit synonymously with avoided cost. We used a detailed analysis. How it differs in tranche 2, there were some differences because of changes that were done. And perhaps that was the context that we had 3 pricing buckets in tranche 1, and we had 9 pricing buckets in tranche 2.
That's fine. I'll take that. I just wanted to be sure I hadn't misunderstood you, and perhaps I did.
Commissioner, this is Gary Rozier.
Mr. Rozier?
I think I can answer that directly. We did the cost benefit analysis exactly the way we wrote it up in the RFP and described it to the staff and all of the adjustments.
That's the answer. You've cleared up my confusion. Thank you. My follow-up question to that was, in reading the RFP, I cannot find myself, perhaps I'm not skilled enough, and that's why I asked the question, a place where a reader of the RFP is told that the output of the net benefit evaluation is the determinative factor for whether you're above or below avoided cost. Is that contained in the RFP? And if so, where is it so stated?
That would be best to answer. David? David, did you want to answer that or shall I?
I'm not exactly sure where it would be in the RFP. I think we described the process of taking the production profiles and evaluating it on an 8760 and also with non-economic factors. So there were non-economic factors that could also result in the elimination of a project. And then the imputing of the system T&D system costs if something went to step 2 was also described. So I would have to refer back to the RFP to see if we, said specifically net energy benefit was going to be the determinant. Again, our context coming in from other places is that a model built on detailed 8760 times 20 years of Duke's forecast of avoided costs, that the result of that model would be avoided costs. And so that may be part of the lack of clarity in that when we calculated the production profile against Duke's avoided costs, the result of that would be, is it above or below avoided costs? And I certainly appreciate the distinction that's being made about the avoided cost prices, those 3 levelized prices, which by its nature average a lot of hours into smaller buckets, and then it levelizes it across 20 years into a single figure for those 3 prices. So it doesn't surprise me that the result of an analysis of a detailed 8760 over 20 years for a proposal that had a really, really small price decrement, it doesn't surprise me at all that it would end up with a negative result on the avoided costs. And just to clarify, the avoided costs we think are perfectly appropriately developed by Duke. Therefore, a standard generic QF qualifying facility, and it assumes that the production is in every hour of every day of every month of every year, and it is not the same as a solar production profile. So the avoided costs are Duke's avoided costs. The solar production profile that is put into the model is the proposal solar production profile. And when you compare the two, that's when you get the net result. And if it's positive, it's good for customers. If it's negative, it's not.
For my commissioner.
Thank you. Yes.
Page 12 of the Tranche 1 RFP, the second paragraph, if I might read just briefly 2 sentences from that. Would that help you?
If it answers the question, please do so.
The economic value of each proposal will be determined based on modeling developed and performed by the IA, period. Dropping down a few lines, each proposal priced used in evaluation will be projected revenues based on net energy cost at the MP's pricing, period. And then the rest of the paragraph is, and that page is a summary of how we would perform the evaluation.
Great. And that was page 12, the second paragraph.
Yes, sir.
Thank you. Let me ask the next question then. Were there, I'm going to have a lot of variables in this, so I'm going to try to take it slowly so you can keep up with me. Were there any other Tranche 1 proposals that were ranked higher on the net energy benefit calculation than Orion's, that did not voluntarily withdraw, that were not eliminated for non-economic reasons, that did not fail to post proposal security, but that were nonetheless eliminated because they were net negative? Were there any higher ranked proposals that were eliminated for the same reason that Orion's proposals were was eliminated?
Yes. And you did an excellent job of putting in all the correct qualifiers, sir. Well, it's not easy, so thank you.
How many were there? 1 or more than 1 that meet
2.
that? 2.
2, sir.
Were both of those proposals asked to post proposal security for step 2?
Yes, they were.
Did they do so?
Yes.
And were those 2 proposals evaluated by the Duke T&D team?
They were not.
They were not evaluated by the Duke T&D team for the same reason that Orion's proposal was not evaluated. Is that correct?
Sir, they were not evaluated because we didn't ask for it. If I could put a slight clarification in, we don't know if independently the T&D team.
Right.
Thank you.
I'm sorry, Mike. Yes, I understood your answer earlier. You didn't ask for them to be evaluated. They were higher ranked than Orions, but they were eliminated from further consideration because they also failed the net benefit calculation.
Yes, sir.
They were net negative. This is interesting. Gentlemen, I'm going to ask Mr. Crisp for a late filed exhibit. It will be a confidential exhibit. I ask that it be filed confidentially. I ask that it disclose the identity of the two proposals we've just learned about. And then I need to find out what else I need to know about them. Well, I can't know anything else about them because as far as Axion knows, they were not reviewed by Duke, but you just don't know.
Correct. We do not know, but I'm sure that Mr. Dirac can help you with that question.
Well, but the decrement, were there price decrements as bid higher or lower than Orion's?
They bid a greater decrement than Orion.
They bid a greater decrement than Orion bid. Both of them did?
So, yes, sir. Again, of all the bids that were received that were conforming, but putting aside, there were a couple that, you know, they didn't post their initial bid fee, that sort of thing, that the Orion bid was the last out of all bids in the ranking. Does that help you with what else you'd like to know?
Well,
excuse me, Commissioner.
Yes, Mr. Roger. Yes.
On that point, that's getting into a great deal of detail about what the decrement was and what the cost benefit ranking was, which are two different things. So I think we ought to take this as subject to us checking on those things, and it can show up in the material that Mr. Chris can provide.
Well, I think I understand your answer, Mr. Rozier. Thank you for that. I think the late filed exhibit should disclose, and it will be confidential. It will be treated confidentially. The identity of the other two proposals, what their ranking was on the net energy benefit ranking, and what the decrement was that they bid.
And again, maybe Mr. Ball or Mr. Monsivacci can answer it with certainty now.
Yes, we have that information, and I might suggest that the megawatts, the capacity might be useful to you, but we have that information.
You're right. The size of the project, the capacity bid would also be useful. Apologies, gentlemen, but this is a new fact, so I'm trying to think as we go about what I need to know.
We understand.
All right.
No problem.
All right. Mr. Ball, a question for you. When you learned recently, as I understand it, that the Duke transmission and distribution evaluation team had done a system upgrade evaluation of the Orion proposal in tranche 1. Did you learn at that time what the results of that had been?
Yes, and in fact, it was just, I think for me, it was just last week that I learned that. So,
right.
And I think the dollar amount that's been spoken of recently is the figure that I'm aware of 450,000.
Well, you've anticipated my next question, which was going to be, when you learned that recently, did you learn the amount that Duke's T&D team had determined? All right.
Yes.
And so let me ask this, see if I can ask this question in an intelligible way. After learning that fact, did you undertake the exercise of determining what would have happened if you had applied that additional cost factor to the Orion Tranche 1 bid and measured the result against the 3 levelized price buckets?
Well, yes, indirectly, we did not have an evaluation methodology in Tranche 1 to do that analysis. There is I think what you might be referring to is the change in Tranche 2, where we added another criteria for passing through. And if that's what you're referring to with the allowable T&D costs, we did look at that. So you would have to assume that Tranche 2's method was applied to the Tranche 1 proposal.
Well, I think you're more precise than my question, and that really is the question. If you applied what you learned recently about the T&D number to the bid decrement that Orion quoted in Tranche 1, where would things have come out?
Well, I don't know where all things would come out. The Orion's bid would have passed that threshold. However, I don't know what would have happened to all the other bids in Tranche 1 that were failed that might have passed also. Several projects, as we just discussed, 2 projects had negative net benefits. We don't have step 2 analyses of those, so those might have passed. And also other projects may have been failed due to their system upgrade costs that in this new method might have also passed.
If I could, Commissioner, just to clarify what Mr. Ball said, not to contradict, but we used, when he said there's a different methodology in Tranche 2, we used the net benefit analysis approach in Tranche 2 as well as in Tranche 1. But by agreement at the request of public staff and agreement with Duke, we also agreed that if we didn't reach our program goal for that tranche, we would identify projects that were net negative benefit, but past the, did not have significant system upgrade costs. So I don't know if that clarification is helpful, but I wanted to share it with you.
Thank you. I understand that. Thank you. All right, I think those are the questions I have. Thank you, gentlemen. You answered a lot of other questions that I would have had, but you answered them in the course of your testimony. So again, Commissioner Duffley or Commissioner Gray, anything? Commissioner Duffley?
Sure. I just have some follow-up questions from what I just heard. In the Tranche 2, were there any awarded projects that did fail that net benefit test, but were awarded or went on to step 2 or awarded? Or is that a confidential question?
I understand the question, and permit me to answer it this way. We provided to Duke the list of projects that we recommended for PPAs based on having a net positive benefit for ratepayers. We also identified which additional projects would, though we found them to be more costly and they were negative net benefit, which would be required to meet the megawatt program goal for that tranche. Duke made their decision as to whether they would extend offers of PPAs to them without our recommendation on those projects. I'm not trying to be semantical. I'm just trying to give you a full answer of the process that we used.
Okay, thank you. And a follow-up question for Mr. Ball. In response to one of Commissioner Clodfelter's questions, specifically, could you go back and analyze now that you have the $450,000 upgrade? Can you go back and analyze it with the 3 buckets, the method, a different methodology to determine whether it would pass through? And I heard you say that yes, it would pass through. However, it would potentially affect, well, you had the 2 other projects that you would need to look to. And then you talked about it might affect system upgrade costs. But and so I just want clarification. In looking at the analysis, it seemed that all of the projects were not interdependent of each other. I think I read that somewhere. So would it really affect other system upgrade costs, or could you explain to me how it could, since they all seem to be not interdependent?
Yes.
David, is that a question that would be better for Ralph, or?
Well, let me clarify, because I think there's some I miscommunicated, or there's some misunderstanding when I talked about there were the 2 other that had negative net benefits, which we did not do step 2 analysis, so we would have to evaluate them. And then the other projects that were failed based on their net energy benefits being positive, it's their additional step 2 system upgrade costs making them negative. We would have to look at all of those to see if any of those would have passed under this alternate method. So yes, they're all independently calculated step 2. There weren't interdependencies. I was just referring to trying to unscramble the egg of tranche 1 that's already been scrambled, and trying to unpack which projects were dropped in tranche 1 that might have to be reevaluated. Does that help?
Yes, that does help. So what you were saying in response was that that when you were talking about the system upgrades, you were speaking of the system upgrade costs for those other 2 projects that were similar to the present project.
Yes, for those 2, which we don't know because they weren't evaluated, but there were other projects in tranche 1 that were evaluated in step 2. When the cost came back, their projects were no longer economic or beneficial to customers. Now, some of those might have been in a really narrow category where they would have been negative on our net benefits, including the system upgrade costs, but might also pass this alternative method where you just look at the price decrement.
Okay, I understand now. Thank you.
Thank you.
Commissioner, with respect to your question about the methodology and calculating it through the 3 pricing options, would you like Ralph to speak to that, because he's really the authority on that issue?
Yes, please.
Ralph?
Yes, I'm off mute.
Mr. Layfield, can you turn your video? I see you, Mr. Montsavage. I got you. Thank you.
And what is the specific question with respect to the pricing buckets?
Could you, if you had the 450 T&D, could you calculate the pricing for each bucket to see how it made out in terms of avoided cost or net benefit?
Well, in terms of the net benefit, what was introduced in tranche 2, occurs is if someone bid, for instance, a $2 decrement, and their energy is 100,000 megawatt hours a year, that's $200,000 per year that could fund transmission if you allowed the decrement to be placed solely against transmission without regard to how it stood on net energy benefits. Did I make myself clear?
Commissioner, I heard you to ask, could Axion use that tranche 2 methodology and determine whether these other projects would have passed if we had a step 2 analysis? The answer to that is yes. And we, in sort of in anticipation of that question, we've done that for the Orion proposal and determined they would have passed. And I think Mr. Judd has already testified to that.
Thank you, Mr. Rose.
But we don't know, but you haven't done that analysis for the other 2 projects that were higher ranked.
That is correct. And the other factor is how recalculating those may impact everybody else that was in the tranche that was calculated somewhat differently.
Yeah, this is Jack Jurack, counsel for Duke Energy Carolinas. I might also add, if we're going to go down that path of unscrambling the egg, as was mentioned, and trying to capture that late file exhibit, there's a lot of other information that we should perhaps consider, including in that, such as whether those additional bids will participate in tranche 2, whether they were selected, how the selections would have changed our current CPRA procurement target totals. I mean, there's kind of a lot of threads one needs to pull if you start to go down this path. So maybe have some latitude to work with the IA to make it the most informative late file exhibit. I think we'll attempt to do that.
I think we're going to give you. I think we're going to give you that latitude because, frankly, doing it on the fly, sitting here in the middle of the hearing, is not the best way to do that kind of thing, exercise. So,
Commissioner, another factor would be if, for any reason, Orion ended up with PPA in tranche 1 instead of tranche 2, then you need to think about the impact that that's going to have on both tranches.
We understand the point, Mr. Crisp. Let me see if there are any other questions from commissioners. If not, I'll go back and ask the council if you want to ask follow-up questions on what the commission has just opened up. And I'll start with you, Mr. Crisp. Do you have any questions you want to ask the panel based upon what questions the commission has been asking?
Thank you. I do not.
Okay. Mr. Jurack?
I do not have any further questions. Thank you.
Mr. Dodge?
Thank you, Commissioner Clodfelter. I do have just a couple of questions. Commissioner Clodfelter, a few moments ago, these questions I think are directed to probably to Mr. Judd. Commissioner Clodfelter started with a question regarding the difference between the net energy benefit tool and whether it was differed somewhat from what was stated in the RFP. And Mr. Judd, you pointed to the discussion on pages 13 of the Tranche 1 RFP. I just wanted to clarify a couple of points about the use of the terms net benefit in the Tranche 1 RFP and then the Commission's approved avoided cost rates. Do you have that Tranche 1 RFP in front of you?
You're asking Mr. Judd?
Yes.
Yes, he does.
Page 12 of the Tranche 1 RFP, that's what you're referring to, correct?
Correct, yes. I think pages 11 and 12 describe the Commission approved avoided cost rates, and then the proposal evaluation starts on the copy I have, the version that was taken under judicial notice has the proposal evaluation section starting on page 13. And
I think you have a different version of MS Word than I do, but it's subsection Roman 5, subsection alpha, correct?
Correct, yes. And you read a couple of sentences from the second paragraph there. And I just wanted to make sure, to be clear, some of the inputs that there are some discrepancies between how the net benefit calculation views that 8760 profile and for avoided cost purposes. Your net benefit calculation does also, and you've discussed, RFP discusses this on the following page, it takes into consideration the curtailment rights that the utility receives under the CPRA bid. Is that correct?
It does, Tim. It's, as you know, there's a whole lot of components and sophistication that goes into that, including the curtailment rights that were identified in the RFP.
Okay. And just you read kind of the statement in that second paragraph in subsection 5. I'm going to read the last sentence as well, and that indicates, it reads as follows: the benefit to the DEC-DEP system is determined using 2 metrics. 1, the proposal's output contributes towards the ability to defer future DEC/DEP generating unit capacity. And 2, the proposal's energy output replaces energy that would have been supplied at DEC system cost for that particular hour. So that statement, again, is referring to the net benefit calculation. This is all describing that the net benefit calculation that's used for proposal evaluation, correct?
I'm sorry, Tim, were you purporting to read the last sentence of the second paragraph of line 5?
Yes, it was. I read it a little quickly. I'm sorry. I'm just trying to move things along.
Well, because the last sentence that I'm looking at discusses how we would deal with storage. I'm wondering if you're looking at the T2 RFP. And
I'm referring, I believe, to the this is CPRA Tranche 1 RFP. The same paragraph you read from is just the last sentence of the same paragraph you were reading from.
Are you reading a sentence that begins with the benefit to the DEC-DEP system, etc.?
Yes.
Tim, that's the Tranche 2 RFP? But we'd be happy to explore that language as well.
I apologize. Am I referring to the wrong version here?
Well, it depends on what you want to talk about.
I'm referring, I've opened up the copy that was taken under judicial notice, I believe, from the Stanley Solar, proceeding. I mean,
and Tim, if I may interject, my copy of the Tranche 1 RFP has the same language. It's just on page 13.
Okay, and mine actually has it on 13 as well. So we may be referring to separate documents. But subject to check, Mr. Judd, would you agree that the Tranche 1 RFP that the Commission took judicial notice of today in the Stanley Solar proceeding, that was the PDF that submitted in docket SP-9590 sub 0, includes that language in the PDF on page 13?
Look, Tim, to help moving this along, subject to check, yes, I was not familiar with the site to that other docket, which specifically identified the document for which judicial notice was taken. But I'm reading the language. Again, I'm finding it on the Tranche 2 RFP, and I pulled the language I read from the Tranche 1 website. But I don't challenge you on the language. Please understand.
Sure. And just to jump up to the top of what's my page 13, but it's the last sentence before subsection 5, the proposal evaluation in the Tranche 1 RFP. The last sentence there, prior to the start of section 5, reads, "For the avoidance of doubt, for purposes of determining the satisfaction of the avoided cost threshold, the system upgrade cost determined by the T&D sub-team shall be converted to a 20-year dollar per megawatt pricing and incorporated into the proposal price."
Tim, I'm sorry, I didn't mean to interrupt you.
Go ahead, Harry. Sorry.
I find that language at the top of, right above subsection 5. I find that in the Tranche 2 RFP. If I don't have that prior page from the copy of the excerpts I took from the Tranche 1 RFP.
And I'll
perhaps, Brother Jirac is on the line. Maybe he can clarify which, if I'm looking at the wrong RFP.
Yeah, I think, again, the statement, I believe it may be in both, but I think the version that we're looking at today, and it's my understanding that the pages may not line up just based on this being an exhibit in a different proceeding. So there may have been some pages changed slightly, but the language I believe is from the Tranche 1 RFP. But just to move things along, I think the point I just wanted to come back to here is, to the extent there is an analysis of system upgrade costs determined by the T&D sub-team, those would be added back into the proposal or the bid price, and that proposal or bid price is the decrement from the commission's administratively approved costs. Is that correct?
Gary Rozier, I don't think that is correct. They get added back to the.
Grady froze.
Well, maybe Mr. Monsivacci can answer it, whether it's an adder on one or a negative on another in the model. It has that effect that you're saying.
Exactly. So the net benefit analysis is benefits less cost, and then you're adding a transmission cost. So it has an effect of reducing the benefit on a $1 per megawatt hour basis.
And I think I was just trying to clarify if it was added back into the 20-year $1 per megawatt hour pricing that's reflected as the proposal price versus the, I guess, the cost that would be part of the net benefit calculation. That was the point I was just trying to clarify with the term proposal price, that whether it was referring to the commission's approved avoided cost rates, the threshold that those represent, or the net energy benefit cost effectiveness threshold.
This is Gary again. That's entirely correct. I think the confusion in answering the question was you used the term decrement in that rather than the prices, net prices. They've been a decrement off of the three pools that produces prices. This is being added into those prices that go into all of the calculations in the 8760 model.
And one last follow-up, and this was a question, Commissioner, in response to a question from Commissioner Clodfelter about the changes that were made in the Tranche 2 memo and the different treatment of projects that had a net negative benefit. Mr. Judd, I believe you indicated that the change that was made would be that if a project had a net negative benefit but did not have significant system upgrade costs, that you would provide those, if the utility had not reached its procurement target for that tranche, you would provide those ranked projects to DEC for determining whether to issue a PPA to those bids. Is that correct?
Yes, Tim, what we said was, and what we tried to lay out in the memo that we posted on the Tranche 2 website, is if we got to the point where the projects that were positive net benefit did not reach, in the case of DEC, 600 megawatts, we would keep going and we would identify for Duke's consideration projects that additional megawatts would be needed to reach the 600 megawatt goal.
But you would not provide to Duke a list of any projects that had a cost that exceeded administratively determined avoided cost rates, correct?
I think the problem there is, well, it's a semantic problem, or it's a problem in terms of how you're defining terms. You know, if you mean the avoided cost based on 876020, then that and net benefit is the same thing.
Right. So we just, again, Tim, and you helped us work with Duke to come up with this approach to try to meet the program goals. And it was, we'll keep going until we reach the 600 megawatts. And you can consider whether the net benefit, as we've calculated it, even though it's net negative, still it's worthwhile to move forward with a PPA. I think that's responsive to your question. I hope it is.
Well, and can I add something? Because it is possible that a project can bid with a decrement and pass that new additional decrement test and have fail that test and have a positive net benefit. That would be one we would want to move forward and not throw out.
Yes, I think that would be in the first bucket up to, if, to the extent you hadn't reached the procurement target. I think if it was still a positive net benefit. Mr. Judd had described a scenario where projects with a negative net benefit may be also provided. And I was just trying to clarify, he indicated that projects that didn't have significant upgrade costs may also be provided. And I was just trying to clarify what was meant by significant upgrade costs. And to my reading of the language in the RFP that we were discussing a few moments ago is that would mean projects that when you add the imputed upgrade costs to that bid did not exceed the administratively determined avoided cost rates.
I'm not seeing the administratively, Tim, the hesitation here is I don't see the administratively determined avoided cost rates in the RFP. And before testifying under oath to the commission, that's what's in the RFP, I had to find the language. I'm not trying to be difficult, I'm just trying to be responsive.
Sure. And one last question then, just to kind of clarify that point. This is on page 12, so I know we're of the RFP. The first paragraph after the table of avoided cost threshold for tranche 1. So you have the table, actually, I'm sorry, that's page 11, spills over to page 12. The first full paragraph following that table, subject to check, would you agree it reads, proposal pricing must be in the same format of 20-year avoided cost pricing periods shown as the tables above. And I described the 3 categories.
Well, Tim, I'm not going to challenge your ability to read, and I didn't have that page in front of me. And I think, so what would you like?
I'm just indicating that statement indicates asking you if that statement indicates that the proposal pricing is based on the 20-year avoided cost pricing periods for the 3 buckets.
It is indicating that we had 3 buckets, and if you can remember back that far, when we helped set up tranche 1, originally we were thinking of 1 bucket, but then we were able to get 3, and subsequently in tranche 2, we had even greater granularity. But those were the guideposts, if you will, for the bidders of what, for those different pricing periods, the combined synthesized avoided cost for those periods, what it would be. And if you recall on the actual bid form, there's a 1 decrement entry by the bidder, and then the website shows them what the pricing would be in each of the buckets when they put in that decrement as a guide to say, this is the pricing that would, if you're successful, will be in a PPA. Again, I think that's responsive to your question.
It is. Thank you, Mr. Judd. I don't have any further questions, Commissioner Clodfelter.
Sure.
All right, Mr. Snow, I'm sorry, Mr. Girak, was that you? No. Okay, Mr. Snowden.
Yes, I do. And Commissioner Clodfelter, before I get to my questions, I just wanted to refer back to the late filed exhibit that the panel has asked for. I would anticipate that the IA fairly would want to not disclose the information about the other bidders and their pricing to Orion, sort of it's consistent with what the approach that's been taken thus far. I would, however, ask that the remainder of that document be made available to Orion. We've entered into NDAs with the public staff and also with the IA.
I think that's perfectly appropriate, Mr. Snowden. We would need to mask the identity of those other bidders from Orion.
Understood. Thank you.
I'm going to suggest that Commission Counsel Ms. Hicks will work with Mr. Crisp, Mr. Jirac, Mr. Dodge, and you in terms of any formatting issues and presentation issues on that exhibit before the exhibit is actually delivered to anybody.
Glad to do that.
And again, trying to do this on the fly is not what we're going to do. So Warren Hicks, who's Commission Counsel, will be talking with Mr. Crisp, Mr. Snowden, Mr. Jirac, and Mr. Dodge about formatting and presentation on that exhibit. So,
thank you, Commissioner Klopfelter.
Right. You may proceed with your questions on Commission's questions.
All right, thank you, sir. And I just have a handful here, and I'm going to take a step and we'll refer back to the Tranche 1 RFP. I've got I think the same pagination as Mr. Dodge, so we'll just have to work through it. But Mr. Judd and Mr. Rozier, I'd like to direct your attention to Section 4 of the Tranche 1 RFP. It's on page 11 of my draft, or my copy.
Ben, I'm going to ask you to give me a chance to get there.
Absolutely.
And just so you know, and the commission knows, the text that I was reading is directly from what is on the IA website for Tranche 1 and listed as final RFP. So I am on page 11, as you asked.
Okay. Do you see Section 4, Roman 4, avoided cost threshold and proposal pricing?
Yep. On my version, that begins at the bottom of page 10.
Okay. Thank you. And you'd agree that this section of the RFP provides the guideposts for bidders for compliance with the avoided cost threshold. Is that right?
It provides guidance for the three pricing buckets and defines there on the page, so it speaks for itself of how those periods are defined.
Okay, but the section is headed avoided cost threshold, isn't that right?
I'm sorry, could you repeat that?
Sorry, the section is headed avoided cost threshold, isn't that right?
One moment. And proposal pricing, yes, it is.
Okay, thank you. And so if a bidder were seeking guidance as to how they would be evaluated for compliance with the avoided cost threshold, this would be the place to look, wouldn't it?
I don't think that's accurate. I think the next section where we describe the evaluation methodology would be that. What this says is, and what was intended to be, was how the different pricing periods were identified and the periods that are covered by each of those pricing periods. Again, when there was a single decrement entry on the bid form, and then it calculated for the bidder what, say, by looking at the chart, the summer avoided, what the rate would be, the decrement against the summer rate for DEC. So I think combined, the entire RFP provided what we thought was the necessary guidance. Also, if you recall, we went through stakeholders process. We also asked, we put the RFP up for comment and asked for guidance from bidders to help us make it possible for them to give us their most robust bids. And this is the guidance that we provided, and we thought it was sufficient, and sure had a lot of bidders not challenge their ability to bid successfully.
Could you please just read the first sentence of the second paragraph of this section? I'm sorry, could you please read it aloud? Sorry.
I've got to get to it, Ben. A sentence beginning with all proposals?
Yes.
Yeah, all proposals, including the cost of system upgrades as described herein, closed paren, must be at or below the applicable 20-year dollar per megawatt hour, then a paren, dollar per megawatt hour, close paren, avoided cost specified in the table below. For simplicity, the avoided cost rates have the energy and capacity rates combined into $1 per megawatt hour rate for the summer on-peak pricing period and $1 per megawatt rate for the non-summer on-peak pricing period, end of paragraph.
Thank you. And the avoided cost rates that are set forth in the table are those cost rates in buckets that we've been talking about, aren't they?
Yes.
Okay. So isn't this the guidance that was provided, or the guidepost provided to bidders for how the cost of system upgrades would be added to their bid costs for purposes of evaluating compliance with the avoided cost threshold?
I'm sorry, I think you're a leap from the what the avoided cost guidance was provided to what would be done with T&D upgrades, if I heard your question correctly.
Well, this sentence indicates that inclusive of system upgrades, bidders' proposals would have to be below the avoided cost rates that are specified in this table, doesn't it?
Must be at or below, specified below. Again, that's when you take the entire 8760 and by 20 and you reduce it to 3 buckets. Yes, that's the guidance that was given so that they would have some appreciation for how to bid.
Thank you. And this section of the RFP doesn't, this section 4 entitled Avoided Cost Threshold and Proposal Pricing doesn't say anything about the net benefit analysis, does it?
It does not. The methodology for evaluation starts in section 5.
Okay, thank you. Those are all the questions I have.
All right, we're at the point where we need to get the exhibits moved into the record, and just to move us along, I'm not going to ask for motions. I'm going to do it this way. I'm going to say that unless there is some objection from a party, we will admit into the record Axion Direct Exhibits 1, 2, and 3. And I see no objection. And we will also, unless there is objection, admit into evidence Orion Axion Cross-Examination Exhibit number 1. And let the record reflect there's no objection there. Gentlemen, did I get all of the exhibits that were identified by this panel?
Yes.
Okay. Mr. Crisp, and anything further from Axion?
No, we look forward to submitting to you the confidential written information that you have requested.
And thank you for that. Ms. Mitchell, I want to do a reality check with you. I may have underestimated the amount of time this proceeding would take. How late can you go today? And don't you get to make the call, Kim Mitchell. How late?
Commissioner Clodfelder, I'm prepared to stay as late as you need.
All right, gentlemen, let's see if we can then finish. I don't normally get that kind of response. I'm going to owe Ms. Mitchell big time. So I think we'll move next, Mr. Girac, to you.
We also always owe Ms. Mitchell big time. So, Commissioner Clodfelter, at this time, I believe we'll be calling just a single witness, Orvain Piper, on behalf.
All right. Mr. Piper, will you raise your right hand, please? Do you solemnly, sincerely affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Girac.
Thank you. So obviously this is somewhat uniquely situated from a procedural perspective. We were not interveners. We have not made any formal filings nor filed testimony in this proceeding. but we were asked to and have presented for commission questions and investigation, Mr. Piper. And the initial commission questions were focused on the T&D evaluation in tranche 1. And so that is the witness we've called here. Mr. Piper is responsible for that. Obviously, the questions we've delved into here have expanded quite a bit. So we don't have a witness necessarily that can speak to the broader issues. I'll just sort of plant a flag that I think I would have some interest in exploring at the end of the hearing what the next steps in this process might be like, including the potential for us to have an ability to file some sort of post-hearing brief. You may already have that in your mind, but with all that said, I think if it sounds good for you, I can ask Mr. Piper a few very general questions to let him get started with the conversation, and then turn it over to other parties who may want to ask questions.
I'm going to give you that opportunity again. This is a bit, again, it's well within the commission statutory procedure, but it's one we don't follow in the normal course of events. This happens to be a bit different. So this is really a witness that's being called at the commission's request. And so I'll let you give us Mr. Piper's background. And then, folks, what I'm going to do is then, since this is really a witness that's been called at the commission's request, I'm going to go first to questions from the commission, and then I will let the other parties ask questions on the commission's questions. But this witness is, again, appearing for a limited purpose. So, Mr. Jurak.
Thank you. Mr. Piper, if you want to begin just by stating your name and just giving a brief your current title and a brief overview of your current role and how you were involved in the tranche, step 2 of the tranche 1 evaluation process.
All right, good afternoon. My name is Orion Piper. I'm a registered professional engineer in the state of North Carolina. I'm employed by Duke Energy, where I'm a senior engineer in transmission planning for Duke Energy Carolinas. As it pertains to CPRE, I'm a member of the T&D sub-team. In that role, I'm one of the individuals who's responsible for identifying network upgrades associated with the bids, as well as their estimated costs.
Thank you, Mr. Piper. And you were directly responsible, I think you said this, for the specific evaluation that occurred in tranche 1, correct? For Duke Energy Carolina?
Yes. Yes.
And you heard some discussion earlier about the chain of events and the interactions that occurred between the IA and the Duke T&D sub-team as it related specifically to the Orion proposal. And if you want to just briefly give a quick overview regarding your role in being informed about the status of the Orion proposal, and then what you and your team did in response to that in the context of tranche 1.
Okay. Around February or March of 2019, the IA indicated to the T&D sub-team that bid 12901 was asked to post bid security. At that point, the T&D sub-team on its own undertook the steps to understand the potential network upgrades that might be associated with bid 12901. This was done in anticipation that the IA was going to reach out to us and formally request that we evaluate 12901 as part of step 2. However, that formal request never came, and the conclusions or the observations of what the T&D sub-team observed was not shared with the IA as part of step 2 in tranche 1.
Perfect. And just to clarify, the reason why you started on the evaluation of Orion, despite the fact you have been asked to do so, was just for purposes of efficiency. Is that the right way to think about it?
That's correct. One of the things with tranche 1, internally we realized that we were up against a tight timeline for tranche 1, and so in an effort to help to expedite the process and be efficient and not cause any further delays in tranche 1 internally, it was the T&D sub-team's judgment to go ahead with running some analysis on bid 12901. It was our first time through the process, so we didn't have a great understanding, I would say, of how much work might be associated with it, so we wanted to go ahead and try to get ahead of it as much as possible.
Great. Thank you, Mr. Piper. Commissioner Clodfelter, I think that's really all the introductory questions that we probably need to cover, and I will let the witness now respond to questions from the commissioners.
Thank you, Mr. Chirac. Let me ask just a couple, Mr. Piper, and then I'll see if Commissioner Gray and Commissioner Duffley have questions too. Were there other proposals like the Orion proposal that you got information from the IA that proposal security had been requested, and you went ahead and did the analysis even though they never got formally submitted to you later by the IA? Were there other proposals like that?
We did receive notification of other proposals who the independent administrator is going to reach out to and request bid security for. Off the top of my head, I do not recall whether or not or how many other projects fit into the same category as this bid 12901.
Did the T&D team undertake the same kind of initiative to try to stay ahead of the curve with those other proposals as it did with the Orion proposal? Did you go ahead and start your work?
If we, for any bids that we received that notification for at around that same time, we would have done that. For bids that were earlier in that process, so the most competitive of the bids, those we likely would have waited until we received official notification from the IA. But as we got towards the bottom of the list, again, understanding that there was a crunch on time with the last kind of wave of projects that the IA indicated that they'd reached out to for bid security, we went ahead and initiated on review on some of those bids.
With respect to the Orion proposal, if you remember, was that interdependent on any other proposal that you were analyzing, or was it independent?
At the time of tranche one, we did not identify any interdependencies associated with bid 12901.
Okay.
Again, that was based on the base case that was established and the assumptions that we made when running tranche one, but we did not identify any known interdependencies.
Did you conclude the T&D analysis on bid 129, the Orion proposal?
We finished the thermal analysis that we would have done that would have been similar to any other bid that we would have evaluated as part of step two.
But you did not provide that result to the independent administrator?
That is correct. That information was not provided to the independent administrator as part of step two and tranche one because we were not formally asked to provide that information. Again, we undertook that so that we would be prepared to provide that information as quickly as possible in anticipation that the IA would have reached out to us with that formal request that 12901 was officially in step two and that we needed to commence with our evaluation.
Thank you. I just want to confirm this. Thank you for that. I just want to confirm this just for completeness sake. It has been represented in the papers filed by the parties that the Duke Carolinas T&D team did not participate in the evaluation or ranking of the proposals other than the work you did on analyzing potential system upgrades. That is correct, is it not?
That is correct.
All right, that's fine. Commissioner Duffley, Commissioner Gray, any questions?
No questions.
Okay, Commissioner Duffley?
Yes. So we heard today about the $450,000 network upgrade. And what I thought I heard in testimony that this $450,000 would be applied to each of the proposal as a baseline network upgrade. Could you please clarify that? Is that an accurate statement?
I would clarify that $450,000 would have been the baseline assumption that would have been applied to bids that were proposing interconnection on a network transmission line. That $450,000 would be consistent with assuming relay and communication modifications at the remote ends of those lines. And so on a network transmission line, there would be at least two. And so using the assumption of $225,000 at each of those remote ends, that's where you get the $450,000 for network upgrades, again, for projects that are proposing interconnection on a network line. That $450,000 would not be inclusive of any additional network upgrades, primarily if there were any thermal constraints that were identified with the bid. For bids that were proposing interconnection on a radial line, that baseline assumption would have been $225,000 in tranche one, and that would just be assuming that we would only need relaying communication back to one end of the line. Again, both of those numbers are baselines, assuming for radio that it's only one location, and for network upgrades that it's only two locations. For each specific bid, depending on the specific transmission line that it's interconnected to, it could exceed that, that baseline estimate of the number of terminals at which we would need to do some work.
And the IA knew this information at the beginning of tranche 1 from DEC?
I do not know the extent of the IA's knowledge of how many remote end terminals might be needed for the specific bids, but over the course of interaction with the IA in tranche 2, as we provided feedback on network upgrades for other bids, it would have become apparent that some of the bids had $225,000, some of the bids had $450,000. And then the only ones that deviated from that were the late stage projects in tranche 1, where there was a completed facility study, and so where we had more accurate estimates that had been scoped and estimated. And so for the projects that were late stage for tranche 1 and had those more up-to-date estimates, those estimates that came out of the facility study were used.
Okay, thank you, Mr. Piper. And my next question is really for Mr. Jirac. I don't think it would be fair to ask you, Mr. Piper, but if you are going to be, if Duke is going to be filing some late filing or after the hearing filing, I would be interested in understanding Duke's position, if you have not already made it clear, about what Duke believes was the avoided cost threshold that was to be used for tranche 1.
Certainly, Commissioner. And that's probably that policy legal question is one we'd be glad to address in some form of briefing at the Commission's discretion.
Thank you. I have nothing further. You're on mute, Commissioner Klopfelter.
Apologies. At this point, Mr. Piper is available for questions, but the questions need to be based upon something the Commission has asked about. So, Mr. Crisp, I'll start with you. Anything?
Nothing.
All right, Mr. Dodge.
No questions.
All right, and Mr. Snowden.
Just a question or two, thank you. Mr. Piper, thank you for being here. Did Duke calculate the likely system upgrade costs for the Orion project in tranche 1?
You're asking about the network upgrades?
Yes, I'm sorry, the network. Yes, correct.
Yes, we did.
Okay, and was that $455,000 sort of basic package?
$450,000, yes.
Thank you. So the Orion project didn't trigger any additional system upgrades. That's determined by the DEC analysis?
The analysis that the T&D sub-team performed for bid 12901 in tranche 1 did not identify any additional network upgrades.
Okay, thank you very much.
All right, Mr. Piper, you got off easy. No exhibits, no motions. I think that completes your appearance. We thank you for being here.
Thank you.
Mr. Snowden, we're with you.
All right, thank you, Commissioner Klopfelter. Orion Renewables calls Tim Lasowski to the stand.
All right, Mr. Lasowski, you've been patiently waiting. There you are. Will you raise your right hand, please? Do you solemnly and sincerely affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Snowden.
Thank you. Mr. Lasowski, can you please state your name for the record?
Timothy James Lasowski.
Okay, and by whom are you employed and in what capacity?
I am the Vice President of Origination and Finance for Orion Renewable Energy Group, which is an owner of Orion Renewable Resources, LLC.
Okay, and did you personally verify the verified petition for relief by Orion Renewable Resources, LLC that was filed in this docket on March 9th, 2020?
Yes, I did.
Okay, do you have any changes to the factual statements that are made in that verified petition at this time?
No, I do not.
Okay, and if you were to verify the petition again today, would the contents of the petition still be true and correct to the best of your knowledge? Okay, Have you reviewed the reply in support of verified petition for relief by Orion Renewable Resources LLC that was filed in this docket on May 26th, 2020?
Yes, I have.
And with the understanding that that filing consists primarily of legal arguments, have you reviewed the factual statements that are in that filing?
Yes, I have.
Okay, and are they true and correct to the best of your knowledge?
Yes, they are.
Okay, so Commissioner Clodfelter, Orion would move that the verified petition for relief filed by Orion on March 9th and the reply in support of its verified petition filed on May 26th and the statements therein be entered into the record as if the contents were statements given orally from the stand.
All right, you've heard the motion. Is there any objection? Hearing no objection, the verified petition and the verified.
Okay. Oh, Commissioner Clodfelter, you're on mute again. I'm sorry.
I'm sorry, it accidentally hit. The verified petition and the verified reply will be received into evidence and taken into the record the same as if testified to orally from the stand.
Thank you, sir. Mr. Lisotsky is now available for questions.
Mr. Snowden, do you want to move the admission of his exhibits A through E to the pre-filed petition as well?
Yes, indeed I would. Please, thank you.
We'll take that motion, and without objection, we will also admit into the record exhibits A through E as attached to the verified petition. Hearing no objection, it is so ordered. They will retain their designation and their confidentiality designations as they were filed. Okay, Mr. Snowden? Anything else?
No, Mr. Lisotsky is available for questions by the commission.
Okay, Mr. Lisotsky, let's see if there are questions for you from Mr. Crisp.
No questions.
Mr. Jurak?
No questions.
Mr. Dodge?
No questions.
Well, how about that? So there's no redirect either. And let's see if there are questions from the commissioners. Commissioner Gray?
No, he may get off the hook.
Commissioner Duffley?
No questions.
Well, Mr. Lisotsky, I have no questions for you either. So this was a long wait for a very short appearance.
Okay. Well,
all right.
Thank you.
Mr. Snowden, anything else?
Nothing further from Orion.
All right, let me ask for good order's sake, because I've been keeping my own notes, but so have several of you. Have we gotten all of the exhibits that anyone wishes to identify or mark or take into the record?
I believe we do, as far as we are concerned.
Okay.
Yes, as far as Orion is concerned.
All right, then let's talk about post-hearing submissions. This is kind of an unusual proceeding a little bit, so I'm not sure. Do you need the full 30 days from the transcript availability? What do you need?
15 days would be satisfactory to us.
Mr. Snowden, does that work for you?
I think that would be fine, sir.
Mr. Dodge, you may or may not be filing anything, but I ask you anyway.
15 days, if it works for the other parties, we can accommodate that. Again, we may, as you indicated, may not be filing anything.
Okay, Mr. Jurak, does that work for you?
Yes, 15 days from the transcript should be fine. I'll just note, though, that obviously we need to get the late file exhibit in, and that is a somewhat complex document. And so I'm not sure if we're going to keep the record open until that's.
Let's do this. Let's make it 15 days from the filing of the late filed exhibit. How about that?
That makes sense.
Does it work?
I think it will, is just so long as there's not a large time to, I wouldn't expect there would be, but from the time we filed that late filed exhibit, as long as we had the transcript in a reasonable amount of time.
15 days from the later of.
Yes.
The transcript or the filing of the late filed exhibit. 15 days from the later of those two events. And again, that seems to be acceptable to everybody, so that's what we'll do. We will, at this point, close the record to further testimony. We will keep the record open for receipt of the late filed exhibit, otherwise close the record for testimony.
Commissioner Clodfelter?
Yes.
Sorry, if I might, before we close, just given the unusual nature of this proceeding, the fact that the evidentiary hearing was initially focused on a couple issues, and obviously we've gone beyond that, Any guidance you have about the scope of what you're expecting in the post-hearing filings would be helpful.
I would say this again. You're right. I mean, some of the things we may have assumed from the written papers we've taken off in different directions than what we might have assumed from the written papers. So let's just say anything that we discussed this afternoon is open for you to discuss and argue as you wish, but you do not need to repeat anything you have already filed. You do not need to repeat anything you have already said or filed with us, okay?
Thank you.
Beyond that, you're on your own. Okay, do we have anything else to take up then before we conclude? If not, thank everybody. And Mr. Judd, I particularly want to thank on behalf of the commission. I mean, we're in a little bit of a difference of opinion here among several of the parties, and that's why we're having this discussion this afternoon to talk about that difference of opinion. But on behalf of the commission, we want to thank Axion for the hard work you've done in tranches 1 and tranche 2 on helping deliver what so far appears to be a fairly successful product overall. So we want to say to you, and since we have all of your team assembled here with us, thank you on behalf of the commission.
Happy to do the work. Thank you, Commissioner.
Indeed. And with that, then, we are adjourned. Thank you all.
I think you just